My name is Jackie Veet. I'm here with my partner, Beth Conway. We're from the law firm of Golenbach, Eisman, Sorbel, and Pesco in New York City. We're both commercial litigators. We also have a robust mergers and acquisitions practice here, including a lot of PE deals. And this topic came to our attention as litigators based on a deal that did not happen in our mergers and acquisition group. The client decided not to go forward with a potential sale of 51% of its company to a private equity firm. And to all of our surprise, the private equity firm sued. And one of the claims that they sued on was a breach of the duty to negotiate in good faith. And when we looked into that, we found out that the Supreme Court of Delaware had opened the door for the possibility of recovery of lost profits on this type of claim in a situation where the potential deal never closed, where neither party had an obligation to close, and there was no signed final agreement. We were surprised to hear that. Our partners in the M&A group were surprised to hear it, and all felt that the law was inconsistent with typical business practices and the expectations of business people and the M&A group. So 2.5 years later of litigation, we obtained a defense verdict at trial after getting a summary judgment decision, which you have in your materials. And we want to share what we learned about this claim and also to help others to avoid what we think are the pitfalls of this cause of action. So this first slide just gives you a roadmap of what we're going to talk about today. First, we're going to explain what is a duty to negotiate in good faith. When do parties have a duty to negotiate in good faith? The duty arises in what are known as binding preliminary agreements, and they also arise if parties agree to them expressly, which we'll go over. We'll talk about what the duty requires of the parties and the risk, what we view as a high risk, which is damages upon a breach under Delaware law. And in our last section, we're going to go over some drafting language for preliminary agreements to try to help you and your clients avoid having a duty and falling into this problem.
Thank you. So as Jackie said, my name is Elizabeth Conway. I'm going to start off by talking about what is the duty to negotiate in good faith. What is this duty that Jackie mentioned that cost us 2.5 years of litigation? It is a legal duty arising in what they call some binding preliminary agreements. It's recognized in many jurisdictions, including commercial jurisdictions such as Delaware, New York, and California, and many others. Technically, it's a form of breach of contract, again, arising from preliminary agreements, which we'll go into in detail, but preliminary agreements are, different types of agreements short of a formal signed agreement. And it can impose certain duties on parties negotiating a potential transaction with liability if the negotiations fell apart. In some ways, it's similar to the implied duty, implied covenant of good faith and fair dealing, and some of the case law, as you might see, will sort of conflate the two, but they are distinct claims. So as I said, this duty to negotiate in good faith arises out of preliminary agreements. So what is a preliminary agreement? It's an agreement that specifies terms on a potential deal and anticipates a future final agreement. Many common examples of these are, letters of intent, term sheets, indications of interest, that type of agreement that in the M&A context is done at the beginning stages of a negotiation. And preliminary agreements can arise in context other than M&A type deals, for example, real estate, but obviously Jackie and I's focus is a little bit more on M&A because that was what our case was on, and that seems to be what a little bit more of the case law comes up with. As the M&A practitioners will know, what we learned is term sheets can vary in terms of their level of detail, which will be very important as you'll see later on. Some of them are very skeletal and just a few pages, and then some of them are very detailed. And that level of detail is important because what M&A practitioners may look at and say, oh, this is very skeletal. It doesn't include, 10 of these major terms that we would never agree to this deal if they didn't go our way. A judge may look at it differently because they don't have the same context that an M&A practitioner has, which you'll definitely see in the case law. So the duty to negotiate in good faith can be either express or implied. Express duty is a little bit easy. It's specifically used with the language written in the preliminary agreement. The parties will negotiate in good faith to attempt to achieve this sale, this purchase, whatever it may be. Obviously, the case law gets more tricky when those words aren't there and the courts are trying to determine if it could be implied from the language of the agreement or the context of the negotiations or lots of other prongs that we'll look at. So the implied duty is where it's not written, but the courts imply it in a binding preliminary agreement. And of course, if there's no duty at all, there's no express duty and the preliminary agreement's not binding at all. Now, what is a binding preliminary agreement? What makes them binding? Stating that they're not binding, as we'll get into, is not definitive on that, which was what our case was really about as well. In Delaware and New York, they've adopted a framework of determining of two types of binding preliminary agreements, although, as you'll see, the framework is not necessarily rigid. Some of the, in particular, New York state cases versus federal cases don't always follow this rigid framework, but many of the cases do. A type 1 binding preliminary agreement is where all essential terms have been agreed upon and the parties agree to complete final paperwork. A type 2 is, and so in the type 1, let me just take a step back, you're really not dealing with whether there's a duty to negotiate in good faith at all. You are bound to the terms of that ultimate deal, and we'll look into that a little bit more. Type 2 binding preliminary agreement is where there's an agreement on certain major terms, but others are left open for negotiation. And again, that is where whether it's implied, that is where the duty to negotiate in good faith comes in. And the Farnsworth article that's cited here is a very interesting article. As you can see, it's quite old, but it is cited in many of the cases talking about a duty to negotiate in good faith, preliminary agreements, and it's definitely a good resource. I would say, in my opinion, it's a little bit more suggests that agreements should be binding, where I think some of the case law now comes out differently, but it's definitely a resource courts rely on. So a type 1 preliminary agreement is, as I said, created when the parties agree on all the points that require negotiation, including whether to be bound, but agree to memorialize their agreement in a more formal document. So you agree to all the major and essential terms in an agreement, but it also says, and you agree to be bound, but it says at some later point, we will incorporate these terms into a final agreement. And a good example of this is this Murphy case I cite here, which is, comes up in a mediation and settlement context where there was a mediation, the parties agreed to all the major terms, both sides signed it, but at the end it says the lawyers will work this out and do a final signed agreement. And that was held to be a type 1 preliminary agreement where the parties were bound by their settlement. And this isn't a total surprise to everybody. Everybody knows if you go into a mediation, litigators do at least, you want somebody to sign on the dotted line before you walk out so that you have both sides bound to what they agreed to at that table. So again, type 1 doesn't involve the duty to negotiate in good faith, but I think it's important to understand the framework of type 1, type 2. So then we get to what is a type 2? And courts employ sort of a 5-factor test to determine whether a preliminary agreement is actually a binding type 2 agreement. And they look at 5 factors. Is the intent seen in the language of the agreement? And this is really the most important. Does the context of the negotiation suggest an intent to be bound? Are there any material terms that are left open? Have the parties partially performed? And is this a final form agreement contemplated? Is it customary in that type of industry? So again, to the most important, what is the preliminary agreement, or what does the document actually say? That is the most important. Does it say non-binding? As you've heard, though, that just putting that word in non-binding is not determinative. Courts will look at the language as a whole, and they really will parse out, and we can explain that in a little more detail in the case that we had, but they really parse out as a whole, does it suggest that the parties intended this preliminary agreement to bind them in some way? And again, they look at, language in the Rembrandt case, certain settlement timeline to a settlement agreement and next steps that they agreed to. And the teacher's case, which is often cited as well, although they reserved rights on certain approvals or final documentation, that alone was not enough in isolation to say that there was definitely no intent to be bound. Some language that the courts have found suggests no intent to be bound and thus no duty to negotiate in good faith is what we cite here in the CK-SJB case from the Third Circuit. And here, again, this is under Delaware law, but they focus on that it will not give rise to any legal binding obligation whatsoever. And then the second part also says, it refers, in our opinion, some very important language, that it won't be binding until a final written agreement, and then by this proposal will give rise to or serve as the basis for any obligation. And this was in an indication of interest, which before this I wasn't as familiar with, but indication of interest, M&A practitioners will know, is a little bit less formal than a term sheet or a letter of intent, but nevertheless, the courts focused on this language as suggesting no intent to be bound. But again, as we said, the words non-binding alone are not determinative. The SIGA case, which is out of Delaware, there's a 2013 and 15 case that we will talk in great detail about today, was a term sheet that at the bottom of the term sheet, the footer of the pages said non-binding. Now, there's lots of different facts that occurred in that case, but nevertheless, it did say non-binding. And then the Bennett case was in Pennsylvania, but similar to Delaware law, where, and you can read it to yourselves here, but this provision was not enough to dismiss the case on the motion to dismiss. And again, as the litigators on the call know, that is at the initial pleading stage based on your pleadings or documentary evidence, meaning the letter of intent or the term sheet itself. But the court found that even though it says here, nothing set forth herein shall give rise to any binding obligations, that was not enough to dismiss a case at the early stage. Now, as you can see, we cite the summary judgment case from the Third Circuit later. The duty to negotiate in good faith claim was dismissed in the Bennett case, but as you can see the difference of the years, that was 4 years later. So one thing we'll also mention is protracted litigation can occur and does occur in a lot of instances under this type of claim. The other prongs are definitely less important in the context of the negotiations. How much were the parties negotiating? Some of these cases suggest 9 months or 2 meetings or conversations may suggest an intent to be bound. Again, that does sort of contradict what common practice is, with many parties just trying to give it the old college try to see if after you sign a letter of intent, if the parties want to move forward with the deal. So the next prong is the existence of open terms. How detailed or how skeletal is the letter of intent? The courts will really look at, does it include all the material terms? Or were material terms that were key not included in there? That is another prong that the courts look at. And again, and you'll see that where agreements are, preliminary agreements say non-binding on them, the cases too, as was in our case, we said, well, we didn't even agree to any of the terms in that preliminary agreement because it said non-binding, but nevertheless, the structure is there in the case law that you have to combat with. Partial performance is largely the same as context of the negotiations. I would say cases say this is sort of the least important factor, but it is certainly one that they look at. And the last one, necessity of a final agreement. Again, this is really the courts look at what is the industry with which this letter of intent or term sheet is signed in, and is it customary for a formal signed agreement to be in place. The likely scenario of most of these, and in most of the cases I've looked at, a final agreement is customary. So in my opinion, this is a less important factor as well, but it's important to look in your context of whatever industry you might be in. And as we said, protracted litigation can very much result from this type of claim. You can see the language. The Cambridge case was the case that Jackie and I have litigated in the Southern District, and it said the words expressly non-binding. Nevertheless, it resulted in several years of litigation. You can see our specific phrase there. And actually, on our LOI, the non-binding agreement was not only underlined, but bolded. And this section said the letter is not intended to be binding contract other than with respect to the sections entitled exclusivity period. And the parties understood that no obligation exists on behalf of either Cambridge to pay the purchase price or on behalf of the company to sell. This, nevertheless, was not enough at the motion to dismiss stage for the Southern District to dismiss the claim of breach of duty to negotiate in good faith against us. The court really went through this, and Jackie's going to talk a little bit more about this at the end stage, but the court really went through our 5-page LOI in great detail. For example, focusing on the last sentence of the first part here, the letter is an expression of mutual intent to proceed with the drafting. The court found at the motion to dismiss stage, maybe this was enough to suggest that there was an intent to be bound here because the parties say they're expressing mutual intent to proceed with drafting agreements. And the next provision also saying we're highly enthusiastic about the prospect of finalizing a transaction. The court really found our LOI at the motion to dismiss stage was, quote, striking in detail, followed up on our due diligence obligations, said there were deadlines to complete and parties were going to defer other projects. And this language, if you compare it with the language that I referred to before in the CKSJB case, it's not as broad as that. In the court at the motion to dismiss stage, this wasn't enough to dismiss it. So the key takeaways are that that the duty to negotiate in good faith can be implied into binding preliminary agreements. The courts will review the entire agreement to see signs of an intent to be bound. Look at these 5 specific factors, but again, they're not rigid, but the language is the most important. Clarity of intent in your preliminary agreements is really critical, which is what Jackie will talk about a little bit more.
So if you have this duty, or if the court at least says you might have a duty until the jury decides whether you do or you don't, what does this duty require? And the policy statements that you see in the cases about why they have the duty and when to enforce it are sort of inconsistent, and there is a tension. We cite 2 examples here. On the one hand, there's language talking about that they want to avoid trapping parties in surprise contractual obligations that they never intended. So of course that would lead toward not holding someone to the terms of a preliminary agreement, especially a type 2, which is what we're talking about, when all the terms have not been negotiated yet. But the other policy issue is the enforcement and preservation of agreements that were intended as binding, despite a need for further documentation or further negotiations. So if the party did intend to be bound, we should respect that intention. So which is it? The case law, as a result, not surprisingly, is often inconsistent and unclear. The first paragraph here states the very common statement of what this duty is, and I'd like to read it because we'll talk about it further. And if you have the duty, a party must negotiate the open terms in good faith toward a final contract incorporating the agreed terms. This obligation does not guarantee that the final contract will be concluded if both parties comport with their obligation, as good faith differences in the negotiation of the open issues may prevent a reaching of final contract. It is also possible that the parties will lose interest as circumstances change and will mutually abandon the negotiation. The obligation does, however, bar a party from renouncing the deal, abandoning the negotiations, or insisting on conditions that do not conform to the preliminary agreement. So, as a practical matter, this statement is really unrealistic. A couple of things I want to point out. The first is that you're supposed to be negotiating the open terms. It says that several times. You're supposed to negotiate the open terms. You can't insist on conditions that do not conform to the preliminary agreement. And then they talk about the others as agreed terms, right? You're supposed to be negotiating the open terms, not the agreed terms. Well, what does that mean? If you're negotiating and you have a non-binding LOI during the course of the negotiation, there could be lots of reasons to revisit a term that is in an LOI. But are the parties here acting in bad faith if they deviate from just focusing on the open terms? Also, this concept of, as long as you both act in good faith and then mutually abandon the negotiation, all is well. Well, I think the corporate lawyers on this call will know that very seldom do you mutually abandon. You reach a point in the negotiations where one party decides for whatever reason no longer to do it. So how often does it happen that there's sort of this mutual abandonment? But this is the case, this is the statement of the law over and over again. And that last sentence, we repeat it because the cases do focus on you're not supposed to renounce the deal, abandon the negotiations, or insist on terms different from the agreed terms. But this is supposed to be a duty of negotiating in good faith. So does it really necessarily mean that you're acting in bad faith if you do these things? That's the crux of the problem. Let's go to the next slide. So what is bad faith? Well, jurisdictions are pretty consistent about what is bad faith. Here's some statements in this context, but bad faith comes up in other contexts and similar language is used. Bad faith is not simply bad judgment or negligence, but rather it implies the conscious doing of a wrong because of dishonest purpose or moral obliquity. It is different from the negative idea of negligence in that it contemplates a state of mind affirmatively operating with furtive design or ill will. That's from the SIGA case from the Supreme Court of Delaware that we're going to talk about, which found a breach of this duty. Further down, the L7 case is a very frequently cited case out of the Southern District of New York, and it also had an appeal. And it states the standard that bad faith requires misconduct or arbitrary or capricious action. And it talks about in that case that bad faith is seen where a party advances a reason to walk away that is merely pretextual. Continuing with this, what is good faith? Good faith requires honesty in fact. A party does not act in good faith where it makes misstatements or misleading statements and fails to correct them. Again, from L7, the linchpin of negotiation is not that one side capitulates to the other, but that there is good faith, honest articulation of interests, positions, or understandings. And again, the L7 case, the quote at the bottom repeats this concept that you have to act in good faith, and one of the ways you act in good faith is to not insist on conditions that do not conform to the preliminary writing, which to me is sort of inconsistent the way that it's written, because maybe there's a good faith reason not to conform. So let's get to that issue, because that's where these cases arise most often. where one of the terms, often the price term, in a term sheet is changed by one party. And then the question is, does that mean you acted in bad faith because you changed the term? Because what if a party seeks to change a term in a preliminary agreement because the economics of the potential deal have changed? They can change for external reasons, such as something in the economy or the market in which the company operates, or for internal reasons. Maybe suddenly they're having a gangbuster year. Their sales have done remarkably well, or something occurs in their business that they're having a fantastic year, and they no longer think that the price that they put in this term sheet, this non-binding term sheet, reflects their value. Now, I'll just want to point out that many of the decisions come up either on motions to dismiss or motions for summary judgment. There's not a lot of cases that goes all the way through trial. Our suspicion is that because these are so complicated for reasons we'll talk about and very fact specific, a lot of times the cases are not thrown on summary judgment, they're not thrown out on motions to dismiss, and the parties are facing a trial and likely there was a settlement. So many times the courts say, well, you know, on this set of facts, a jury could find that you acted in bad faith, or bad faith is a very fact-specific issue. We can't decide now, and it leads it to trial. But SIGA, they did find bad faith there. And as you'll hear, what happened in SIGA was it was in the pharmaceutical context. And there, during the course of these negotiations, they had a very successful trial. And they obtained significant grants from the government and from others. So they suddenly had a lot of money. They had these great trial results. And when the news of the trial results published, their shares tripled in value. So they no longer wanted to go forward with this licensing arrangement that they had put in the term sheet. Now that case is a little different, which we'll get to because there were other contracts. But those are obviously very, you know, significant changes for the business and led them to raise the price. We mentioned here two other cases, both out of Delaware. In the Green Tech case, denying summary judgment, where a party backed out of a joint venture or a potential joint venture, given legitimate misgivings about the proposed deal, but the court said that reasonable minds could differ as to whether it amounted to bad faith. The Iacono case, at the bottom, there was an internal email saying, wow, could this be our ticket out? And because of that email, the court said there could be a question as to whether the defendant was negotiating in good faith. Again, denying summary judgment, leading the case to trial. Now, there are cases which say that there is not bad faith when there's a change of economics, because that's a good faith business reason for taking the action you're doing. L7 being one of them in New York, where the court said acting in one's own financial self-interest in response to market changes does not constitute bad faith. The White-Winston case that we mentioned here, which is just in 2023, this is the federal court in Delaware, not the state court where SIGA came out of, but it was applying Delaware law. And here, and in this case, the parties had a fully negotiated sale agreement. To the end, they were waiting, pens were poised, ready to sign, and the party that was selling, the CEO had real misgivings about the deal, didn't think they were getting what it was worth, and convinced the board not to go forward. And so they went back to the other side and said, we want more money. And that's what led to this litigation. And here, the court, after a trial, this went all the way through trial, and it was found that they had not acted in bad faith by raising the price at the 11th hour. The court emphasized, this was a judge trial, and the judge emphasized that the case, the facts must show a conscious doing of a wrong because of dishonest purpose or moral obliquity, quoting the same language we mentioned earlier, and that here the defendant was entitled to raise its price or even walk away to find another buyer, as long as it did not mislead White-Winston, the other party, about whether it had done so. And in this case also, there was evidence that they knew that when they raised the price, it might kill the deal. The court said that doesn't make it bad faith. As long as they were honest, and they had good reason, and that's what's found, but again, at trial. Now, our case, the Cambridge case, and we have the 2023 site somewhere, I think. Here, in the summary judgment decision, which was in June of 2023, the court specifically said that the negotiations are not limited just to open terms. So that was interesting that the court went that far. The court said that the language suggests that the party, in deciding whether you have a duty to negotiate in good faith, you're looking to see if the parties intended to be bound not to the specific terms contained in the LOI or to the ultimate contractual objective, but rather to the LOI's framework in which the parties would negotiate the final deal in good faith. And later, he similarly said, to say that an agreement imposes a duty to negotiate the open terms in good faith, however, is not necessarily to say that the terms that are not open can never be revisited. He gave some examples and said the law is not so rigid that it precludes either or both parties in a type 2 relationship from revisiting one or another element of an agreed preliminary term if necessary to settle an open term. And in our case, on summary judgment, the court noted that in our LOI, like the LOI in the White-Winston case here, it merely memorialized the parties' tentative assent to a sale price or to the terms because it was a non-binding LOI. So again, this is the Southern District of New York, a federal New York court looking at Delaware law. So whether necessarily the Delaware Supreme Court would agree with this, we can't say, but certainly this court spent a lot of time and effort looking at this cause of action and analyzing many of the cases, and it's a 90-page summary judgment decision. So you can take a look at that. We've listed some other cases out of the Seventh Circuit and District of Massachusetts that are similar. So a takeaway here as to what constitutes a breach of the duty. As you can see, it's a very fact-specific analysis with a focus on the reason that the party changed the proposed term or a reason that the party abandoned the negotiation. And it's hard to escape litigation when it's a very fact-specific claim like that. It's further complicated by conflicting tenets of law and the application, which leads to greater litigation risk. Even when the parties believed they didn't have a final agreement, they were working off a non-binding LOI, and then believed that they acted in good faith. Now, we just wanted to mention at the end, an interesting issue that came up in the Cambridge case, is the interaction between an exclusivity provision, which is frequently in a letter of intent, and this duty to negotiate in good faith. And the question the court addresses in the summary judgment decision is when a binding exclusivity period ends. So in our case, the exclusivity period was agreed to be 120 days, and then it ended. After that, a party is free to go out and negotiate with other people. And how can you, if they're free to negotiate with other people and seek whatever terms they want, why would it be bad faith to seek those same exact terms from the party they've been negotiating for months with and still have been unable to get to a deal even at the end of the exclusivity period? Now, I know that exclusivity periods are often extended, but this one wasn't. And it gets into a very interesting interaction of these two bodies of law.
So before I jump in, I know for New York, there is a code that for New York attendees, and the code is good faith with a space.
Repeat it because they can't hear it again.
Okay. All right. For the second time, the code is good faith with a space.
You'll have to put that in to get your CLE credit, and we're not allowed to email it to you or anything or put it in a chat, so you've heard it.
All right, so next we're going to go to the very important part of what are the potential damages for a breach of this duty, and that's really where a lot of what this comes down to. Damages are critical in a case. as all practitioners know, typically reliance damages are what are recoverable on a breach of the duty to negotiate in good faith. Reliance damages are usually limited to professional expenses incurred in connection, like during your negotiation, legal fees, accounting fees. They're not always limited to that. There can be an opportunity you've lost in reliance on the promise to negotiate, and that gets a little trickier, but most of the time it is, you know, your out-of-pockets, what you relied on. It excludes lost profits, which is really what it comes down to. It excludes the idea that I should get the damages that I would have incurred if this deal went through in a year from now and we actually negotiated a final deal, signed that, and went forward with it. That's lost profits. And the real world impact of this is that the SIGA case, and I'll get into that in detail, opened up the door to expectation damages being potentially recoverable on this type of claim where they typically had not been before. And the real world impact of that is that, you know, it makes the potential of settlement at an early stage nearly impossible. That makes the cost benefit analysis for a plaintiff bringing this type of claim a lot different than the cost benefit analysis if you think you're going to get your $200,000, $300,000 in legal fees versus, you know, in our case, it was $30 million versus $400,000 in reliance damages. So that's a huge difference. And it really is a big real world impact into how, whether a party brings a case at all, how much they pursue it, whether they go towards trial or not. So that's really why it's so important. And as I said, Delaware law opened up the possibility of expectation damages on this type of claim. And really changed the playing field and sort of allowed this type of claim to be weaponized in jurisdictions even outside of Delaware, as we saw here in New York. And as I'll explain in a little bit, there is some older case law that doesn't totally foreclose this idea, but it does it a lot in dicta, saying, you know, all damages that are recoverable in some case need to be reasonably certain. They need to be foreseeable. And there's no way that it's very unlikely that you can have lost profits be reasonably certain when neither party had any legal obligation whatsoever to do an ultimate deal, and the terms of whatever that ultimate deal may be are unknown. So I'm just going to go a little bit on the roadmap and go through SIGA, what the case was, and how it really changed the playing field. That it still is, in our opinion, the exception, not the rule, and cases have really narrowed it and limited to its facts since then. So as Jackie mentioned, the SIGA decision was out of the Delaware Supreme Court. There's a 2013 case and a 2015 case upholding the damages there, and it was in the drug development context. There was a license agreement term sheet that was negotiated between the parties. SIGA had a new drug, as Jackie mentioned, with promise, but needed money to do it. And the defendant came in and became that party. They signed what was expressly non-binding term sheet for a license agreement. At some point, they thought a merger might be better, so the parties hedged a little bit. They signed a merger term sheet referencing this license term sheet. But SIGA needed money to go on, so asked for a bridge loan. So then there was a formal signed bridge loan agreement whereby the defendant gave SIGA $3 million. And expressly in that agreement agreed to negotiate in good faith the license agreement on, quote, substantially similar terms than what was in that term sheet. And then, as Jackie said, SIGA was hit with a big grant and they had seller's remorse. They terminated the merger agreement, which they were allowed to do. And then the defendant said, okay, it's time to negotiate our license agreement. And SIGA came in with a completely different set of terms that did not match what was in the term sheet. And at trials, they found SIGA acted in bad faith and breached the duty by insisting on terms that were substantially different than what was in the last agreement. and awarded $113 million in expectation loss profit damages for what the plaintiff would have made had this deal gone through. And, you know, this case sent waves in the legal world and the M&A world, because people would say, how could you possibly get $113 million expectation damages when nobody was legally bound to enter into any license agreement? They could have negotiated it and it didn't work. And the trial court there found that it was a quote type 2 agreement, and then found that the expectation damages were allowed based on two key factual findings. One, that the parties memorialized the basic terms of the transaction of the license agreement and expressly agreed in the bridge loan agreement and then subsequently in a merger agreement that was later terminated. And but for SIGA's bad faith, the parties would have consummated a licensing agreement. And really, it treated the licensing term sheet as the ultimate contract. And the dissent in the SIGA case went crazy and said this was totally departing from commercial jurisdictions, awarding expectation damages on what was an expressly non-binding term sheet. Now, again, you heard the facts. It was very different. There were multiple other agreements that were expressly entered into that incorporated this non-binding term sheet. But nevertheless, it was enforcing a licensing agreement that the parties didn't expressly enter into. And again, the New York Court of Appeals, we cite the case here, that is not allowed in New York. And the leading case says because it transforms an agreement to negotiate for a contract into the contract itself. And California, the case we cite here, says the same thing. But the dissent in SIGA is very interesting because it picks up on one struggle that we had in our case, was that Delaware has adopted this type 1, type 2 framework from New York courts, but then, and applies that, but then drastically changes the application of that framework on its damages assessment. So it really creates this asymmetry where the SIGA case has now this broad language that says if you have a type 2 agreement and the plaintiff can say that the deal would have gone forward but for your bad faith, then expectation damages may be available. And that framework, that sentence in broad language, because SIGA didn't limit it specifically to those facts, has become problematic in this area of the law and really cited again in all of these cases that deny summary judgment or whatever, because if you do have a type 2, the question of whether but for you could proceed, the transaction would have occurred is really a fact-specific question. And the dissent in SIGA talks a lot about reasonable certainty, which I referenced earlier. How could it be reasonably certain that these expectation damages would have occurred when nobody had to move forward with the deal? So this is really the exception, not the rule. And there is another case in Washington, and again, like some of these cases do allude to the fact that this might be possible theoretically in dicta, but not really applying it. And Washington law has a similar case like that, Columbia Park Golf Course, 160 Wash App 66 from the appeals court there. But again, that was very different like SIGA. It was not what we have here and in what many of the cases are, which is just a letter of intent that both sides are trying to see if they like each other in order to move forward with a transaction. So the SIGA case has been disfavored and its reach narrowed. I think that in the 10 years since SIGA, we're not aware of any case that has actually awarded expectation damages in reliance on SIGA. The trends in the decision seem to be going towards narrowing SIGA. You heard Jackie mention that earlier in our case, and in the White Winston case in the federal court of Delaware. The White Winston case is a very interesting case that there was a letter of intent, as Jackie said, that was signed, and at the 11th hour, one side demanded a higher price than the other. And I won't go through it in detail because she already mentioned the courts rejecting expectation damages, saying that LOI, like the Cambridge LOI in our case, did not agree to the ultimate economic terms of a potential deal. It was just a, quote, tentative assent to a sales price, deal structure, in order to see whether the parties were going to move forward. And so the Delaware court really made its own, said, I don't think that the Delaware Supreme Court really meant this case SIGA to apply to a non-binding LOI like I have here, and so made up his own type 3 and said that something different than type 1, type 2, type 3 agreement could be formed when parties have a duty to negotiate in good faith, but do not agree to any of the final deal terms. And so in that situation, the White Winston judge said, reliance damages are all you're going to get. And on a motion in limine before trial, kicked out expectation damages. Notably, in that case, there was reliance damages of $5 million that the plaintiffs were seeking, and one of the issues that didn't end up having to be decided by the court because it didn't get to the damages section was, you know, the plaintiff was really trying to repackage their expectation damages. And in our case, as we've mentioned, the Southern District, Judge Lyman, really also limited, in our opinion, limited SIGA, saying that SIGA didn't apply to what we had here, which was really a non-binding LOI. And Judge Lyman didn't adopt the type 3 sort of framework that the Delaware court had, but again, similarly distinguished SIGA from the set of facts that we had, and again, dismissed expectation damages on summary judgment as a matter of law, saying they weren't recoverable. In our case, we had a dispute whether New York law or Delaware law applied, but the court found, obviously under New York law, that it doesn't allow expectation damages, and then said under SIGA that it also would not apply, because really focused on foreseeability and saying it is not foreseeable in our context in a non-binding LOI that these type of damages would be recoverable. And in the pharmaceutical industry, it is a little bit more foreseeable under those facts where you had all those agreements, you had a $3 million loan, and there was an intended business relationship between these parties, regardless of how that was going to be merger or license. And then he also focused on, in our case, there was no, quote, zone of possible agreement during the negotiations. Again, going to that second prong, would this have occurred but for bad faith? So it's very important, limiting, we believe, and also he mentioned that SIGA was narrow and has been applied as such by the Delaware courts. So, oh, and yes, as we mentioned at the beginning, at trial, the question of whether there was a duty to negotiate in good faith and whether that had been breached went to the jury, and the jury found on the first question, no, there was no duty at all in our LOI. So it didn't have to get to whether there was a breach, but found there was no duty. But again, that was after 2.5 years of litigation. So I will now go to the most important thing, which is how to draft to avoid such a duty.
Before the most important thing, I'm told to repeat the most important thing, which for all you New York lawyers out there, the code one more time is good faith. That's what you need to put down to get your credit. Okay. Back to the other very important thing. We want to talk about drafting LOIs, drafting term sheets to try to avoid this duty, to ensure that non-binding, if that's what the parties want, that that's what you get, and to give some language and pitfalls about some of the disclaimers and other language. The first point, which Beth mentioned, I just want to reiterate, it's really important. Judges and litigators do not read letters of intent the way corporate lawyers do and the way business people do. They read every word, they parse it, they take it literally, and they don't know what's missing. They don't know what another one might have looked like or could have looked like, or, well, you know, our corporate lawyers look at them and say, well, yeah, but where's the XYZ term? And that's not what the judge is going to see at all. He's just going to look at it and see, well, I see price, I see quantity. That sounds like the key terms to me. So, so one of the most important things really for business people to know, and, you know, the corporate lawyers to know, is it's very important that parties have corporate counsel at the LOI stage who know what they're doing. I think a lot of times business people just sign LOIs by themselves without getting their deal counsel involved at that stage, and they think it says non-binding and I'm covered. And as you now know, that's not so. So I would encourage people, please, to use real deal counsel at the LOI stage. Non-binding. Use the words. Say it many times, as clearly as you can. And you want to say that it's not going to have any legal effect whatsoever. The LOI, the letter of intent, the term sheet has no legal effect whatsoever, that the negotiations can have no effect. As Beth mentioned, the non-binding language existed in ours, but the judge didn't find it quite good enough. Now, I know that many letters of intent have binding provisions in them. So there's pieces that are binding and there are pieces that are not binding, and it's very important to draft it to be extremely clear of which sections are binding, which paragraphs are binding, which are not. And are the business terms binding or not? When you have the price terms, etc., I assume that's in the non-binding part, but make that clear. We listed here common binding agreements. The confidentiality provision in it can be binding, the exclusivity provisions. In other words, everybody agrees they're binding, and if there's a breach, someone could sue for breach of contract for breach of those things, whereas the others are non-binding. That's fine. The fact that you have binding terms doesn't mean that you definitely have a duty. You just have to be extremely clear of what's binding and what's not binding. Common to say, you know, we need final documentation. We have no deal till there's a final, signed, you know, executed sale agreement, something to that effect. Don't expressly promise to negotiate in good faith. If you do, you now have the duty. Even if it's not a type 2, it doesn't matter. You now have the duty. So when we speak to our corporate partners about this, people have said, well, you know, sometimes you get an LOI from the other side and it says, oh, we're all going to work in good faith toward getting to closure on this deal. And if we strike that, what kind of optics, you know, does that send to the other side? And our suggestion is you get past that. It's really important not to make an express duty to negotiate in good faith. I suspect the other side doesn't want that duty either if they really knew what it was. And just explain that it has independent significance, and you know we're all going to work on this diligently, but we don't want this in the LOI. And we suggest that the safest option is actually to disclaim having any duty to negotiate in good faith, if you can get there with the other side in your LOI. Choice of law, as you now know, Delaware law puts a much greater risk on this cause of action with the possibility of expectation damages. We know that there's lots of considerations that go into the choice of law and agreement, but certainly from this perspective, we would say avoid Delaware law, pick something else. New York is one good option, I would think, and it's also a business-friendly jurisdiction, and there's others too. Avoid what we call feel-good language. There's sometimes these letters of intent are used by business people or investment firms as almost like a marketing piece also to try to sell their offer to the company, and they include all kinds of language in it that they don't really mean as part of an enforceable business deal, and they may not view them as the business terms, but the judge is going to read them, and the judge is going to take them literally just like any other term. So we put a few of them up here as examples. We would urge you to convince your business people that the LOI is not the place for their marketing, and to keep the letter of intent to business term very, very legalistic, very objective, and just, you know, get in at what you need. I thought it might be interesting to be corporate lawyers here before I get to the disclaimer. In our case, in Cambridge, when we went on the motion to dismiss and we had that whole paragraph that said non-binding agreement, in bold and a whole paragraph dedicated to it that we would have a good shot at a motion to dismiss, and as you know, we lost at that stage. So what were some of the things in the agreement that the court saw? I'm just noticing the time. Okay. Some of the things that the court found were persuasive were a statement, the fact that the company had agreed to do its business as usual during the course of the negotiation, that there was a sentence that they gave an expression of mutual intent to proceed with the drafting of a share purchase agreement. That was a big one. He found words that were mandatory and not just aspirational, that made the parties have an obligation to proceed, even on due diligence, which I think is pretty common. And he thought the major terms were in there. By summary judgment, he realized that many terms were not in there. He looked at it a little differently and ultimately allowed it to go to the jury to decide whether there was a duty or not. The strong disclaimer language, very important. You want to disclaim any liability arising from the negotiation of the potential deal, as well as disclaiming any liability arising from the letter of intent itself, except for the expressly binding provision. This is language from the White-Winston LOI, which frankly we think is pretty good language for this context. We've highlighted here what we liked because it says not binding and no legal effect, etc. But we will note that there was another phrase in the same LOI that said that they have exclusivity for the duration of negotiations. And because of that phrase, early in the case, the court found that that constituted an express duty to negotiate in good faith, because one party was now bound by an exclusivity throughout the negotiations. So of course they must have all understood that to mean a duty to negotiate in good faith. And again, then right before trial, there was another motion where he threw out the expectation damages, and at trial found no bad faith. But this, on what's on your screen now, wasn't good enough to get rid of the case because of a different phrase elsewhere about exclusivity for the duration of negotiation. And finally, we're putting back up on the screen language you saw earlier from the indication of interest, and we've highlighted and read the sentence we like, that no liability relating to the negotiation of the terms of the transaction should be part of your disclaimer. And just, 1 minute left. Here's a quick review. Parties have a duty to negotiate in good faith if there is an express agreement or if it's implied in a Type 2 preliminary agreement. It's a very fact-intensive analysis to decide whether it's a Type 2, and then it's a very fact-intensive claim issue to decide whether there was a breach. So either or both of those can lead to protracted litigation. The big risk of a breach is damages in Delaware. And so drafting of the LOI or the term sheet is extremely important to avoid the duty, which we assume both sides would like to avoid. Thank you.
Yes, thank you very much.
Go on. Was there a question? There's still on. There's somebody submitted a question in the chat about that NDAs. So I guess this is a separate, a non-disclosure agreement has a sentence that it's not, they do not intend the NDA to be binding, and could good faith be applied in NDAs? That's the question. I don't see what, I mean, it's not limited to preliminary agreements, so I guess it could be. It could arise there as well. It can arise in any preliminary agreement, but usually preliminary agreements involve an expectation of a later agreement. So I'm not sure when this context arises where you have a non-binding NDA. Usually the ones I've seen have been binding, but.
Right, and I think if the NDA is truly just for the exchange and non-disclosure of information, sometimes the NDA, and what we saw in one of the cases, 37 Celsius, that I'm not sure we cited in here, but there was an NDA and a letter of intent, and the NDA actually included some helpful language on limitation of liability, but the NDA itself wasn't the sort of agreement to agree. So there wasn't there wasn't sort of a duty to negotiate some future deal implicit in the NDA. I suppose there could be some NDA that had that type of language or for future agreement in it, but a typical NDA, is the way I think of it, is really just for the, confidentiality of agreements exchanged, not necessarily for it incorporated in an NDA is not usually the economic terms of a new deal. Usually that's in a separate agreement, which would be a preliminary agreement if it was a separate letter of intent or term sheet or something.
If anyone else has questions or is interested in this topic, feel free to reach out to either one of us. I think you have our email addresses, and there's some materials. You can find us on the internet.
Yes, thank you very much. It certainly, for us, was an interesting type of law that I think when I first learned of our case, I had no idea that it existed, and I think our clients as well were banging their head against the walls for 2.5 years saying, this was non-binding. So as we've mentioned, drafting is critical and really informing your clients at an early stage. So thank you very much.
Thank you.